Labrīt!
Good morning, colleagues, friends. I'm deeply honored to see all of you here today in Riga.
Sometimes can be still unpredictable, as you can see outside the window, but therefore we tried and prepared an excellent and diversified agenda for today. And I hope you will have a chance for an insight in intellectual property and beyond. Patents, trademarks, industrial designs, innovations, intellectual property rights enforcement, and their clear link with economical growth and competitiveness. These are our main topics for the next 2 days to come, and we look forward for our presenters to take the stage and share their vast experience. And Latvian innovators as well from the outset knew the value of their inventions. And as an example, I can mention one of the first patents granted to Latvian, which was in 1921, for the plucking and processing of flax machine. But this trend continues till now, and I can mention in last years our patent office granted such patents in various fields as chemistry and medicine, where new substances to fight cancer are being discovered, physics, inventing optical tables for use in medicine, and of course not forgetting as well new fields. For example, green technologies, where wood ash sorting machine has been invented and fuel consumption monitoring devices. I would like to continue with a small quote from great French writer Victor Hugo, which said that there is only one thing stronger than all the armies of the world, and that is an idea whose time has come. And I'm sure that we all know that ideas are strong and that they are valuable, but you must protect what is valuable. And only then you will be able to use full potential and force that is embedded in these ideas. Dear ladies and gentlemen, after looking around the room, I'm in awe with the expertise and great knowledge gathered here today. And without further delay, I'm deeply honored to welcome you all here in Riga. And with great anticipation, I look forward to hearing our next speakers. And I'm honored to give a floor to our first speaker, Mr. Dzintars, Minister of Justice, for an opening speech. Please, Mr. Rasnačs, floor is yours.
Esteemed participants of the conference, ladies and gentlemen, I'm very honored to welcome you, all of you who have gathered here to discuss topical issues of protection of intellectual property. I would like to thank Mr. Francis Gurry and the World International Property Organization, also Mr. Shambo and Mr. Sermio and Ms. Kirsten Warnes for the possibility they have found to participate in this conference and to share the insights they have made in this work in the world, in Europe, and also in Latvia. Protection of intellectual property rights is one of the most relevant issues. Knowledge-intensive economy is the only way for European countries to compete in the global market. The protection of intellectual property rights is a very important mechanism that Europe can use to support innovative commercial activities of its companies. A number of companies are responsible for protection of intellectual property. These are two ministries, the Ministry of Justice and the Ministry of Culture. The Ministry of Justice develops policy in the field of industrial property, whereas the Patent Office of the Republic of Latvia, in accordance with this jurisdiction, is the institution which is implementing this policy. The main task of Latvian Patent Office is to accept applications for legal protection of intellectual property rights subjects and to issue documents. Latvian Patent Office also contributes work for educating society and for public awareness raising. This has been underscored in policy planning documents of national level, and we should improve public awareness about intellectual property rights and about exercising these rights. Likewise, policy planning documents underscore the development of inventors' activities activities, also research in the field of intellectual property right, and preventing and combating piratism on the internet. A system for effective protection of intellectual property right depends upon member states and also regional and international organizations and cooperation between these organizations. Over time, Latvian Patent Office has developed very successful organization with WIPO, also European Patent Office, and also Organization for Harmonization of Internal Market. A number of important projects have been implemented in this cooperation. They ensure successful operation of Patent Office, improves the quality of the service, and also increase public awareness of the protection of patents, trademarks, and design samples. Latvian interests are also represented at WIPO. Representatives of Latvian Patent Office are actively involved in the work of different committees of industrial property right. Harmonized system of intellectual property rights is the basis for creativity and innovations in the European Union. Latvian cooperation with OHIM is also increasing and growing. It's important to mention those programs of the office that Latvia participated in. For example, in the framework of Cooperation Fund, Latvian Patent Office has implemented 18 projects, which is a very important indicator at the background of all member states. And this outlines the future aims and purposes of the Latvian Patent Office. Likewise, cooperation takes place also as part of the convergence and bilateral agreements. Latvian Patent Office has always had the aim to provide high-quality service. That's why an important step for future development of the organization is the recent possibility that has been now provided to file applications online. We must note that this service has been now implemented in cooperation with Organization of Harmonization of Internal Market. Also, the Center for Monitoring Violations of Intellectual Property Rights is very important. The findings of the results help explaining to society the importance of intellectual right protection. Likewise, the issue of united patent protection system throughout the European Union is very relevant. Different activities are now underway to implement European patent. And Latvia has signed also the agreement on implementing European Patent Court and also this regional chapter of Baltic and Nordic countries of the Patent Court. At the end of last year, Latvian Patent Office and European Patent Office signed a bilateral cooperation plan which envisages a number of joint cooperations, ensuring the development of European patent network. This plan is very important for continuing this cooperation. As a result of this, the users will be provided the existing and improved services in the field of patents. For Latvian companies, research institutions, their recognizability and visibility is very important, and also the protection of their inventions is important. We are very proud of products that are intellectual right intensive at the Institute of Organic Synthesis, at Grindex company, Primex company, and in other Latvian companies. We are proud of these inventions. They make the word of Latvia known in Europe and also over the world. It's important to be aware of the role of intellectual property rights and to provide legal protection to it. This will increase competitiveness of the state and also will promote successful development of the state. This means that also in the future the Latvian Patent Office will have to invest very serious work to continue their activities and their work. Today, I would like to thank and express my gratitude to the Latvian Patent Office and the director, Mr. Sandris Laganovskis, for all the activities and the measures that have been implemented aimed at promoting protection of intellectual property rights. I would also like to thank the organizers of this conference for their contribution and for their work. Esteemed participants of the conference, I wish to you the very best of success in today's work. I hope that this conference will bring new ideas to you, and I hope that the conference will give you new professional knowledge. In conclusion, I would like to say that successful economic development is possible only and solely in an environment where the rule of law prevails. Thank you for your attention.
More the Minister Dzintars Rasnačs, and unfortunately Mr. Minister needs to leave us because the work in Parliament doesn't stop even in time of presidency. And now I would like to give the floor to Dace Melbārde, the Minister of Culture, for the opening remarks, please.
Distinguished guests, ladies and gentlemen, it's a great honor for me to stand here in front of you as Latvia recognizes and praises flourishing international cooperation in the field of intellectual property rights among policymakers and stakeholders from all around the world. The same as in the field of industrial property, also in the field of copyright, Latvia has strong commitment to have the most appropriate legal protection for results of creativity of mankind as a vital tool to ensure economic and spiritual prosperity of the society in a long-term perspectives. Copyright protection provided for the results of creative endeavors in the fields of art, literature, and science has served for the promotion of culture, innovations, and the development of copyright-intensive industries throughout decades. Copyright has always faced necessity to respond to the technological development and subsequent changes in the ways how works are distributed and consumed. This challenge we witness also in the contemporary world when technological changes are extremely rapid. In turn, it requires an appropriate response by means of legislative and non-legislative solutions. The protection and enforcement of copyright and other intellectual property rights is of utmost importance to creative industries. In December of the previous year, the Council of European Union adopted conclusions stressing its commitment in combating infringements of intellectual property rights. Among other matters, the Council recognized the importance of developing new competitive business models, enlarging the legal offer of cultural and creative content, and at the same time, preventing and combating piracy as necessary means for fostering economic growth, employment, and cultural diversity. I would also like to add that action aimed to increase the legal offer of the content protected by copyright should be supplemented by the awareness-raising campaigns. The information on the ways how the works protected by copyright can be acquired legally should be provided in a user-friendly manner for all society groups. As it was highlighted also in the speech of my colleague, the Minister of Justice, Mr. Rasnačs, intellectual property plays a significant role in contributing to economic growth. From the perspective of the culture policy, it is of great importance to have copyright as a tool to provide fair remuneration to authors and those who facilitate the creation and dissemination of copyrighted works, and thus contributed to enriching of the cultural diversity. Extensive and effective European Union-wide and international cooperation of all parties involved played the key role in achieving considerable achievement in the field of copyright. Within the course of the presidency, Latvia facilitates the coordination of the European Union position in the work formats of the World Intellectual Property Organization. In its national capacity and with regard to priorities just mentioned, Latvia has increasingly close cooperation both with the World Intellectual Property Organization and the European Union Observatory on infringements of intellectual property rights. I believe that this cooperation regarding the protection of intangible goods will lead to intangible results. And I also believe that further progress will be achieved during the conference organized by our good partners like Latvian Patent Office. I wish you all a fruitful discussion and enriching exchanges of experience and ideas.
I would like to thank very much Ms. Dace Melbārde, Minister of Culture, for these opening remarks. And now I would like to give the floor to Dr. Francis Gurry, Director General of the World Intellectual Property Organization, who could join us with a keynote speech. Please, Mr. Gurry.
Thank you very much, the Honourable Minister for Justice, Dace Melbārde, the Director of the Latvian Patent Office, Sandris Laganovskis. Ladies and gentlemen, it's really a pleasure and a privilege to be with you this morning here in Latvia during the Latvian Presidency in the beautiful city of Riga on such a beautiful day. And I'm very grateful for the opportunity to be able to speak this morning and to share some thoughts with you about the state of play, really, of intellectual property internationally. So let me start, if I may, with the obvious, which I think has been emphasised already by both ministers, and that is, of course, that we're in the middle of a massive transition from really an economy based on physical capital to an economy based on intellectual capital, an enormous shift where we see that the rate of investment, at least in many of the advanced countries, in intellectual capital or intangibles is increasing at a rate which is much higher than the rate of investment in physical capital. And we see in consequence that increasingly intellectual capital and intangibles are the basis of wealth creation. That, of course, has had the consequence of raising the stakes for intellectual property, because intellectual property captures the competitive advantage that is conferred by innovation or by investment in intangible capital. And we see in consequence that throughout the world, really, competition is increasingly based on innovation and on intellectual property as the battleground for that competition, since it is the means of securing competitive advantage. That general situation, which is a consequence of the shift from a tangible to an intangible economy, is compounded, I think, from the point of view of competition by the changing geography which we see in economics generally, but also in technology. We see, for example, that in our area of intellectual property, last year, or 2013 at any rate, Asia accounted for 58% of all patent applications filed worldwide. And I could give you as an anecdote graphene, which is a wonder material, new material, and which was invented in Manchester, actually, in 2004. Since that time in 2004, over the course of the last 10 years, there have been 11,000 patents granted or patent applications filed with respect to graphene in the world, and 2/3 of those have been filed in Asia or out of Asia or by Asian entities, despite the origin of the invention. So that changing geography, of course, enlarges the sphere of competition on the basis of innovation, and it introduces a range of new players, and so makes the competition much more difficult. I think also compounding this focus on innovation, or on competition rather, is the general policy consensus that one sees across the world with respect to innovation. Of course, in the advanced countries, innovation is an explicit part of their economic strategy, and this would apply, for example, to the largest economies in the world. We see that with the United States, with Japan, with China, which is officially on a journey from made in China to created in China. We see it with Germany and so on as you go down. It's also I think, a policy consensus that exists in the middle-income countries, seeking to avoid the so-called middle-income trap. And the way in which they do that is through value addition, thus innovation and intellectual property. And I think you could say that across the world, really no country wants to compete on the basis of the cost of labour. And so everyone is looking for value addition, and thus the stakes with respect to competition in relation to innovation are rising. And finally, I think one could cite globalization as a factor also that is enhancing the competitive stakes. As has been said by one economist, in an environment of open markets and globalization, labour and capital tend to drift to the location of highest value use, which makes ideas and innovation the scarce resource. So we have, I think, this as a general context, but that competition is taking place, of course, in an increasingly complex environment, naturally, as a consequence of the focus on competition. We see complexity enter into the picture, and we see very active agendas at the national level, at the bilateral level, and at the plurilateral level, and at the international level with respect to intellectual property. An example of that complexity, I think, are the discussions that are taking place at WIPO with respect to the revision of the Lisbon Agreement on appellations of origin. As you know, the member states of the Lisbon Union have decided to revise that treaty. The diplomatic conference will take place in May of this year. And generally speaking, the objectives are to open the agreement to a broader range of countries, including intergovernmental organisations, to raise the level of protection that applies, the higher level of protection that applies to wines and spirits, also to other agricultural produce. And we see that at the same time as these discussions are taking place, of course, they are an important part of discussions taking place in the context of the Trans-Pacific Partnership, and they are an important part of the discussions taking place in the Transatlantic Trade and Investment Partnership, as well as an important part of many bilateral agreements. And I think I cite that without any comment on whether that's a good thing or a bad thing, but just as an example of the increasingly complex policy environment in which we are all operating in the field of intellectual property, which raises ultimately, I think, questions of coherence and questions of timing with respect to these multiple discussions and agendas that are taking place. I would say also that the general environment is complicated by the contested politics that surround intellectual property. And I think the main focus of those contested politics tends to be on access, because, of course, what intellectual property does is to make access a saleable commodity. That's the basis of technology markets, after all. But at the same time, it raises important political questions and issues with respect to the possibility of access and the cost of access, and those are played out most acutely with respect to health, medicines, and creative works on the internet. So the result is, I think, a very complex environment, a difficult environment for policy making in the field of intellectual property, but one in which economically intellectual property assumes a much more important position and a much more central position in the contemporary economy. We see, as a result, that demand for intellectual property rights continues to rise at a rate that really outpaces the growth in the world economy. So in 2013, there were some 2.37 million patent applications filed worldwide. Depending on how you count them, either nearly 5 million or 7 million if you count classes, trademark applications, and about 1.24 million design applications worldwide. So an extraordinary demand for intellectual property. And as a consequence of the complexity of the environment and the contested politics, at the same time perhaps a reduced capacity to agree on the part of the international community. Turning to the agenda of WIPO in that context, I would say that one of the fundamental question that we face as an organisation is, first of all, the challenge of positioning in that rather complex and rapidly changing environment. What is the value added that an international organisation can make in that context? And I think this is the question that the organisation and the member states come back to time and again. What is the special value? What needs to be done at the international level as opposed to the plurilateral level or the regional level or indeed the bilateral or the national level? And we have really four main objectives, I would say. There are perhaps more sub-objectives, but let me focus just on four that we feel are extremely important. To some extent, to use European terminology, they represent acquis, but we should work to ensure that we retain the acquis of over 100 years of international cooperation in the field of intellectual property. So the first of our objectives, of course, is to really globalize our global intellectual property systems, namely the Patent Cooperation Treaty, the Madrid system for trademarks, and the Hague system for industrial designs. These are, of course, strong systems. Each of them has been experiencing very healthy and robust rates of growth. And I think we shouldn't forget that it would be impossible, really, to establish systems such as these in the current environment. So they're very precious assets that we need to focus on and to ensure remain healthy and robust. Insofar as the geographical reach of these systems is concerned, the PCT is at about 149 member states, the Madrid system at 93, if I'm not mistaken, but covering now 110 countries, because one of the contracting parties is the African Intellectual Property Organization, covering now some 17 countries. And the Hague system is at 49. So one of our objectives is to bring all of these systems really to a stage where their geographical reach really is global. We are delighted with the developments that are occurring with respect to the Hague system and the Madrid system in particular. As you know, last year the Republic of Korea joined the Hague system for designs, and just 2 weeks ago Japan and the United States joined the Hague system. So these are major new developments for that system, which I think will increase its viability and its attractiveness across the world. We still see activity in respect of Madrid. I mentioned OAPI joining next week, or this week, later this week Cambodia will join it as part of all of the ASEAN countries, the Association of Southeast Asian Nations countries, objective to join both the Madrid system and the Hague system. And I think we will see Canada join both systems by the end of this year, which is another major development. Apart from expanding the geographical reach, of course, we're very interested in ensuring the quality of the work product internationally. Users will not use the system unless it is they are reliable and credible systems. So emphasis on quality is certainly there. And the cost effectiveness of the systems. In this respect, excuse me, in this respect, I would like to point out that we have not raised the fees in any of these systems for the last 6 years. And I think we're probably alone amongst intellectual property officers in this respect. One of the challenges for those systems, I think, is to face the new realities of demand, which I have mentioned, and the demand in particular that is coming out of Asia. It is being discussed within the context of the Madrid Working Group. But if you consider a country that uses a non-Roman script for a trademark, such as China or Japan or Korea, then the basic registration will be in Chinese characters or Japanese or Korean characters. And that raises a big problem for the use of the international system, the Madrid system, since the international registration must be based on the basic mark. So I think this is something that we need to confront as an organisation, the member states, in order to ensure the full use of these systems by non-Roman script countries. Let me move away then from the global systems. I think another objective that we have, which is more and more aspirational, I must say, is the development of the international legal framework. This is a very, very difficult area because of the context that I mentioned at the outset and the difficulty and complexity of that context. But we nevertheless have a number of outstanding projects which we would like to see the member states bring to fruition. And they include, of course, the Design Law Treaty, a new treaty on broadcasting against signal piracy, and there is the question of the Intergovernmental Committee on Traditional Knowledge. It's very difficult, as I said, to see ways forward in these complex areas. I must say that personally, and it's not necessarily the view of the member states at all, personally I think that one way forward is for the organisation to focus on those areas where agreement is possible and just not focus on areas where it's apparent from the outset that agreement is not possible. So to translate that rather abstract notion, it means, I think, that it is possible to move forward in procedural areas and areas of functional standardisation, which are absolutely essential in an era of global markets and global economic behaviour. But it's not possible, I think, to move forward in any area that is covered by the TRIPS flexibilities, because I don't see either side, if I may say, really wanting that. One side fears the enlargement of the TRIPS flexibilities, and the other side, if I may say, fears the narrowing of the TRIPS flexibilities. So we almost know from the outset that these are areas in which agreement is not going to be possible, and I think it should lead to a greater focus on the procedural harmonisation and functional standardisation. Let me say also that I think that generally speaking, if you look at what is happening in all of the international organisations, we do see that the nature of international cooperation is changing. And to some extent, we see the demise of the treaty as an instrument of international cooperation. There are very, very few treaties concluded internationally across the whole spectrum of international organisations these days. In 2012, for example, when the Beijing Treaty was concluded, there were 4 treaties, multilateral treaties, concluded internationally, of which the Beijing Treaty was one. In 2013, when the Marrakesh Treaty was concluded, across the whole of the multilateral system, again, there were only 4 new multilateral treaties. If you compare that to the output of a national parliament, you see it is extremely reduced. So the reduced capacity to agree really is something that exists right across the whole of the multilateral system. And I think one of the things that is happening is that the speed at which multilateral negotiations take place is so slow that it is getting out of sync with the speed of developments in the external world, and we see less reliance on treaties in this context. And I think that is not necessarily a tragedy. I don't suggest that we abandon treaties at all. I think we just have to face reality and accept that there are other ways of doing international cooperation. Let me give you one example, if I may, and that is the agenda that exists within the Standing Committee on Copyright to create an exception and a limitation with respect to educational uses or educational institutions or educational works. I think when one goes down to ask what it is that is the problem that the demandeurs seek to address by this, usually the answer that we hear is the high cost of textbooks. And I think the reality is that an educational exception would not address that problem. So you have, if you like, one side of the spectrum which considers the education exception as a limited exception for limited uses of certain parts of educational works in certain circumstances, and the other side of the spectrum that sees it as a means of obtaining free or cheap textbooks. So a complete mismatch, if you like, in expectations, and it's not necessarily by an exception that you are going to address the fundamental problem that is at the base of the demandeur's demand with respect to this particular item. You might be able to address it, for example, and I'm not making any formal suggestions here, but you might be able to address it by creating a list of the 100 most needed textbooks or 200 most needed textbooks in the world and subsidising their distribution. Publishers have spoken about giving away copyright in certain developing countries free on condition that when it is used there is 20% local content, which would prevent the re-importation of the works through parallel importation into their competitive markets. This all to say simply that there are means of international cooperation to address objectives that the international community might set, which do not necessarily involve treaties. If I may, I would like to say one other thing about this general area of norm-making, since it is the most troubled area or the most difficult area in which to answer, and that is, I think there is a cost for not agreeing, and there is a cost for not agreeing internationally, and there's a cost for not agreeing nationally. And that cost is that given this pace at which developments occur in the external world, the cost generally is that policy is made by default by the market. And that may produce good results, or it may not produce good results. But I think we're seeing that in a number of different areas. I would suggest, for example, that with respect to the whole digital revolution and the whole migration of creative works from analogue formats to digital formats, essentially the biggest progress has been made by new business models in the market as opposed to legislation. And the greatest compliance, perhaps, with respect to copyright has been achieved by accessible new business models such as streaming and subscription services. And they have done more, perhaps, than legislation has done. So there is a cost, because I think that leads us to assess what is the results of those market developments. And one might suggest, for example, that one of the results is that there is an enormous concentration of value in the distribution function. Who is making money in this new world? Well, it's the Googles, the Amazons, the eBays, the Facebooks. And what about the creators, which, of course, was the basis of copyright in the beginning. And this is played out in the little dispute between Taylor Swift and Spotify, of course, as one example. So I think there is a cost, and we should bear that in mind as we go forward in a difficult environment to try to find new norms that can be established at the multilateral level. Let me mention briefly then, in conclusion, two other areas of great focus for the organisation, and they are, first of all, global infrastructure, what we call global infrastructure, the infrastructure underlying the operation of the intellectual property system worldwide. We feel this is an extremely important area. Said in other words, if you like, very crudely, it's all about data and data cooperation and platforms rather than treaties. So we have important agendas in the area of global databases for patents, patent information, trademarks and designs, for international cooperation in the delivery of IP services, such as our digital access service and the centralised access to search and examination results, which now 17 countries participate in. Public-private partnerships, such as WIPO research, which is a consortium of now nearly 100 members, including the major pharmaceutical companies, universities, national institutes of health, to share intellectual property in the area of neglected tropical diseases, or the Accessible Books Consortium, a consortium of publishers, libraries and the World Blind Union to make available published works in accessible formats for visually impaired persons across the world. One of the reasons why I think these public-private partnerships are possible is because they do not harm the competitive interests of the owners of intellectual property. So if you take the area of neglected tropical diseases, the reason pharmaceutical companies can share their compound libraries, their libraries of compounds, is because there is no market for neglected tropical diseases. They affect the poorest persons in the world who have no purchasing power. So there is no market loss in the sharing of intellectual property. And to some extent it's the same with books available in accessible formats. The reason why there is a book famine for visually impaired persons, essentially in cold economic terms, is because there's not enough visually impaired persons to make a viable economic market, which makes the sharing of intellectual property, again, a possibility, provided the right safeguards are in place. Let me just say a final word then about development, which is another important area for the organisation, an important objective, increasing the capacity of the developing countries to participate in and to use the intellectual property system. And I think our major challenge in this area is to try to develop across the world a shared understanding of the value and contribution of intellectual property to economic development. And of course, that shared understanding escapes us as an international community, but it nevertheless remains the objective. It escapes us, I think, because to some extent there are lingering legacies of economic conditions which have been completely passed by. We have a political architecture still in operation that really reflects the economic realities of the 1970s rather than the economic realities of 2015. To some extent, it's a Geneva problem in that it's more difficult in the context of Geneva, where there are many international organisations with agendas that complicate, I think, decision-making. and to some extent it's because certain outliers exercise disproportionate influence. Nevertheless, we continue to try to develop the shared understanding, and in terms of the organisation's program, we seek, I think, in particular to align our program, the development program, to our organisational objectives. And I would mention two areas very briefly. We are keen on working with member states on the development of intellectual property, the use of intellectual property in respect of particular national objectives. I could give you the example of a country like Tanzania, which has as a national objective to transform subsistence agriculture into commercial agriculture. And I think here our obligation is to try to find ways in which intellectual property can support that national economic objective, which you can see through geographical indications, branding, and through new plant varieties, as an example. And finally, I think in this area we are also very keen on practical programs. We have a new set of programs relating to the use of off-patented technology to solve pressing social problems, such as water filtration, in terms of appropriate technology. And that has been very successfully deployed in a number of countries so far. So I thank you very much for this opportunity to be able to speak with you this morning, and I wish you a very good conference.
I would like to thank once more Dr. Francis Gurry for this keynote speech. Thank you very much. And now I'm glad to give the floor to our next speaker, Ms. Kirsten Journa, Director for Industrial Property Innovation Standards of European Commission. And she will address with the news from our region. Please, Ms. Journa, the floor is yours.
Thank you. Minister, dear Sandris and Francis, ladies and gentlemen, and dear friends of the IP community. In Latvian folklore, a crystal mountain symbolizes the height of achievement, something not easily attainable. The prince had to walk up to save the princess, but full of rewards for those who make the commitment to reach this peak. In Latvian literature and folklore, they also speak of the Castle of Light to describe this, and I understand that this fantastic building in which you host us today is called Castle of Light, and I think, given the topic of our conference, the presidency couldn't really find a better place to have this conference, and I really want to thank you for this. Now, when it comes looking from the world, coming back and looking to Europe, I think this is the first meeting of the IP family in the broader sense after the entry, after the beginning of the new political cycle under President Juncker. And I would like to use your title, IP and Beyond, to zoom a bit on the bigger picture, to zoom out, and to look at the priorities of intellectual property in the new political cycle. I want to start with a Spitzenkandidaten experience, because for the first time for European Parliament elections, we had Spitzenkandidaten campaigning for being president of the European Commission. And when you talk to our Spitzenkandidaten, there was one experience that really marked them, and in particular our president, President Juncker, who has been around European politics for 30 years, 20 to 30 years. And what marked them, and we hear it also from different commissioners, is the fact of speaking to audiences like this about Europe and getting a feedback, very skeptical, sometimes critical, and explaining that all the wonderful ideas that were invented in Brussels actually are very different when they are applied on the ground in the different member states. And this fact of campaigning for this job led to a very different concept of this college on how we should make European policy, and what's the role of the Commission in this. For this Commission, it translates into what we call, in our own jargon, the 10 Juncker priorities. These are the 10 priorities that will shape the way the Commission works and what the Commission seeks to achieve for the next 5 years. I'm just going to quote them to give you a flavor of this. These 10 priorities are a new boost for growth and jobs, a connected digital single market, a resilient energy union, and a forward-looking climate change policy, a deeper and fairer internal market with a strengthened industrial base, a deeper and fairer economic and monetary union, and this, by the way, is Vice President Dombrovskis' area, a reasonable and balanced free trade agreement with the US, an area of justice and fundamental rights based on mutual trust, towards a policy on immigration, a stronger global actor, a union of democratic change. That's all. And everything we'll be doing, the Commission, will be part of these 10 priorities. This week, the Commission adopted last week, the Energy Union package. The Digital Single Market package is scheduled for 6th of May. The big investment package to boost growth and jobs was presented at the end of last year. And the narrative and the actions will link back to this. Now, if you look at the 10 priorities, you see that growth and jobs is the focal point, and you also see that lots of these will require innovation. So innovation, if you want, is the red thread in the red thread of the 10 priorities. And that's where the role of intellectual property also comes in. But before coming to the work on intellectual property that we are together doing at the moment in the European Union, I would like to show you a little photo, virtual, of the EU and the state of play in the EU industry today. And this photo shows the following features. Aging. Our industrial equipment is aging. We have a gap of 30 billion of investment if we look at depreciation. In fact, our industrial equipment depreciates more quickly than we invest into it. An investment gap. Aging. Intangible based. 39% of the EU GDP is delivered by IP-intensive industries. That is, industries that are based on intangibles as their main business model. We're also talking about a quarter of all jobs. Connected, in fact, not yet connected. In a recent survey, only a quarter of European companies felt confident that digitalization, the possibilities for having more automated production processes, for example, they felt equipped for it. So 3/4 of the companies do not feel equipped for using these new technologies. And then, unfortunately, the fourth feature of my photo, stagnating. We will publish in some weeks the European Union scoreboard, innovation scoreboard, which we publish every year. And what we will see is that most countries stagnate. And we're still far below investment levels in innovation, 20% actually, today compared to before the crisis. The photo also shows the European paradox. It's in Europe with its ideas, the creativity, which translates into the patents and the ideas into the different offices you are responsible for. So we have world-class technologies and we have ideas. In fact, the world comes shopping in Europe when it comes to automation, to robotics. 45% of our experts. But our companies do not use them. Now, the question is how to address this paradox. We feel very strongly that we have to look at the value chain. It's not enough to only have the ideas. It's not enough even to only register the ideas in Europe. What is important is to get investment, to get money, financing, to develop these ideas and to develop them in Europe, not go to other countries, to bring them into the market in Europe. I just want to make one example about advanced manufacturing. Advanced manufacturing is organizing your production process, your logistics around it, your distribution process in a way that takes account of technological examples. I want to make two examples here. One is Coty, the cosmetics company, and they introduced sensors into their production process so that filling the little bottles with the cream or perfume, whatever, they wouldn't spill. And for €1 invested in the sensor technology, they saved €3 about not spilling the cream or whatever. That's an important example. But it took a long reflection to introduce this because they had to think about the whole process. It was not only establishing the new machine, a new machine. It was establishing the sensors, connecting it to a platform, having software that would be analyzing what was happening, having software that would be analyzing and robotics that would be readjusting the filling stations. First example of advanced manufacturing and where we actually want to go. BMW. They have a factory in which they try to have a cooperation between human and robots and to have the robots doing the heavy work. And one example is adding the door to whatever car model I forgot of BMW because the door is heavy. So the robot takes the heavy door, puts it into the car, and then the person, the human next to the robot can interact and do the finishing. These are two examples that Europe has the technologies, and collectively we have to make sure that these technologies also get to the market. And this is for all levels. It's for regional levels, and I would like to mention the Vanguard initiative, which is 20 regions throughout Europe who collaborate on promoting innovation and technologies getting into production processes. It's at member states level. There are a little dozen member states that have innovation programs. In Germany, it's called Industrie Punkt 4. But there are member states, different member states have different issues. And it's by focusing on the technology, the users of technology, and the skills. You always have to bring these three together. And Latvia, that will be shown in the innovation scoreboard, is making very good progress and is in fact an example on bringing technologies to the market, to the SMEs. So, what is the role of intellectual property in all of this? We believe that intellectual property, whether they're called design or patent or copyright, they are an essential infrastructure for our companies to reward investment because they help the company that has developed the technology idea into the title to attract financing for that matter. I will now go through the different work strands that we have at the moment. First work strand that comes to mind obviously is the patent. 25 member states signed up for the unitary patent title, and that means for companies one-stop shop to register their patent and a patent that is valid throughout the 25 member states, no fragmentation, and the possibility to defend this patent also in one single jurisdiction. You don't have to chase your patent through 28 member states. You can have one single jurisdiction. What's still missing to get it going? The right price. The fees for the new unitary patent will be essential, and the discussions are only starting, and many of you I see around are part of this. The right fees, they're the litmus test. If the fees are too high, companies will just not use the new tool. And we very strongly believe that if it's about giving companies, also smaller companies, the possibility to leverage money, financing for their ideas and technologies in Europe, we must have a cost-effective system for them to get this new title. We hope that the first unitary patent will be delivered in 2016. We are looking forward to it. And of course, we need member states to ratify. We only have 6. We need 13. And we count on the collective mobilization of the IP family to make sure that we have 13 ratifications in 2016. Trademarks. We have a major overhaul, and again, I see many who painfully have been through, I don't know how many meetings in the last 2 years, overhaul of the trademark system. I think we're there almost. There is a final trilogue between the Parliament and the Council scheduled before Easter, and with a very engaged presidency, we hope that the package will be adopted by the May Competitiveness Council. What will it bring for companies? Again, a streamlined, easier to handle system to register their trademarks and defend their trademarks. And for offices, it will provide a really good tool for cooperation projects and for improving the general state of the IP infrastructure in Europe. Copyright. I already mentioned that the digital single market package is planned for the 6th of May. This will announce already some features of the copyright reform, but the legislative proposal is expected for the autumn. And of course, in this legislative proposal, and Francis, you mentioned it, and if we look at this building, the digitization of cultural content and the maintenance of cultural diversity and the dissemination of culturally diverse works will be one of the important parts of this package, because that's the fantastic opportunity that the digital single market offers to all its citizens to discover new things. The trade secrets proposal. This is kind of a cousin of copyright because it's not of intellectual property, because it's not intellectual property proper. We proposed a text that would protect trade secrets in the whole of Europe and facilitate also the defense of trade secrets. The proposal has already been agreed by the Council, and we expect the Parliament to follow suit very quickly. Probably the adoption will be either at the very end of the Latvian presidency or in the beginning of the Luxembourg presidency. We will have to see. That depends on the Parliament. What will it do for companies? It will do 2 things. The first is that it will give them a secure area where they can share innovation and they can share ideas. Because today it's not developing one idea into one product. Today it's complex products and companies have to work together. They have to develop together. Today, this development across border, this working together across borders is hampered by the fact that they don't know if they can really trust each other. Whether they don't know each other's, will my ideas be protected in the other country? So that puts a strain, and they prefer to go to the US to work together in Silicon Valley rather than do it in Europe. The trade secret proposal will give them this additional space and will be clearly, there will be one standard in Europe how to protect the ideas and trade secrets in a given cooperation. The other important thing it will do for companies is also that when a trade secret is stolen and the goods or whatever is produced from a third country, today there's no way, well, there is a way. It can come back into the single market and then you have to hunt it down in every country of the single market to stop it. The new rules will give the possibility for companies to stop it at the external borders already. So a much more efficient possibility to defend trade secrets. Then the minister already mentioned enforcement. That's a very important issue, and I think gradually everybody realizes that in the digital world you need cooperation on enforcement. You cannot do it within the national borders only. We proposed an action plan on enforcement in July, and the main features of this action plan is focus on commercial, not private, focus on commercial, free riding, and follow the money. Of course, you can stop people from enjoying or from downloading illegally, but the real problem are those who make a business model out of providing illegal content. And they make a business model out of it because either advertisers put their advertising on these websites, or they make a business model out of it, which is even cheekier, because they make innocent people, trusting people, pay for the illegal content via payment systems. So our focus will be on trying to make sure that these two money streams don't get to the illegal websites anymore. Cooperation with advertisers, that they blacklist or refrain from having advertising on such rogue sites, and cooperation with payment operators, that they do not provide payment services to such websites. That's the focus. Another focus is supply chain. Supply chains are longer and longer in the globalized economy, which means that the possibility for infiltration of fakes in these supply chains is also bigger. And we believe that, again, you have to go to the source. As the IP owner, you also have an obligation to make sure that your supply chain, the partners you have in your supply chain, respect the conditions and play according to the rules. And that they don't have a factory that 8 hours per day produces according to the license and overnight produces a lot of fakes, for example. Enforcement design review. We are having design legislation which is more or less of the same age as the trademark legislation, European, and we think it's timely to review the functioning of the legal framework, but also the economics of it. And the economics of it in particular in the light of new developments such as 3D printing, for example. We are currently doing 2 studies on this, and that process, I expect the first results end of this year, beginning of next year. And part of this package is also, of course, also the issue of spare parts. Is there design protection for spare parts? The Commission at a certain stage, 10 years ago or longer, proposed that spare parts should be liberalized. And that proposal was blocked in the Council for a decennia. And the Commission has now withdrawn this proposal, which hasn't made a lot of people very happy, strangely enough. But also this problematic will be part of, and it's very relevant for the car industry, will be part of that review. I only have 2 more. The before last is IP, technology, and standards. Standardization plays a key role in getting from the technology into the market. It plays a key role for the new Internet of Things. When my fridge communicates with my supermarket to order 10 eggs because I have no more eggs in my fridge, which seems to be the future, then we need interoperable standards. The fridge needs to be able to talk with the supermarket, for example. That's standards. Now, standards, in particular in ICT, is technology. And you have to integrate the technology into the standard, but the standard is for everybody. And there's a tension at the moment. There are very heavy debates at the European standardization bodies, ETSI and CENELEC, about the role of standard essential patents. What we see is a big conflict between two types of industries, the innovators, mainly in Europe, and the implementers, mainly elsewhere. Implementers want that standard essential patents are standards, no patents, no exclusive rights anymore. And the innovators think in a standard essential patent, underline the word patent, exclusive right, license. We've had now a kind of escalation because one of the important US standard setters, IEEE, enacted new rules 2 weeks ago, according to which standard essential patent, standard is this, and patent is this. There are hardly any exclusive rights anymore to exercise for the owner of a patent that's part of a standard. But if companies, innovators, do not bring their technology, whether patented or not, into standards anymore, the future will not happen. Because you may wonder if you really need the future about my fridge talking to the supermarket. But if you think about machines communicating with machines, if you think of my sensors in the Coty example, communicating with a platform, making sure that there was no spill of the product, then that's another story. So there is a real debate to be had, and it's for the time being taking place in the standardization context. But I think the IP community will also have to start getting involved and considering. And then our very last point, big data. Big data is the big thing everybody is now considering. What does big data mean? It means to collect data, to assemble it, to process it, aggregate it, use it. It's happening at the moment. When you Google or on any search machine, data about you are being captured. And you may wonder why all of a sudden you get these offers and these advertising. That's all big data. Now, the issue is whether we can leave this entirely and totally to the market. And the answer is no, because there are certain types of data which are already regulated. Copyright is an example, because copyright are data that enshrine a certain creative content, and that's why they are regulated. Databases, software, regulated. Privacy, personal data. We have the big regulation under discussion. We have one example, satellite data. The Commission is the owner, the Union is the owner of 2 satellite systems, one called Copernicus, which makes photos of the world, of the Earth, 24 hours per day, and the other Galileo. On Copernicus, we have a huge wealth of data, but companies didn't dare to use them because they said, I don't know whether they will be available in the future, so I make a big investment to analyze and process these data, build my business model, and then one day maybe they're no longer there. What happens if the data are corrupt? They're not correct. And therefore, this is the only area, I would say, where we really regulated big data. We have a regulation that establishes the ownership of the data, and with that the liability, which is on the EU, but at the same time gives free access. Now, the question is whether for the business models of the future, there is an issue about the ownership of data and the liability and the contract law. These are debates we're having at the moment in the context of the digital single market package. But I'm convinced that some of the experience we have with IP legislation, which is also granting a property right, defining the scope, and around it the public domain, and defining limitations and exceptions. Completely open, but I just wanted to launch that as well, because I'm convinced that there's a lot of expertise for this type of debate in the IP community. And then, of course, there's WIPO. Francis, some solutions have to be global because value chains are global, and more important, because capital is mobile. And if you want to have leverage your IP for capital, then that IP has to be recognized also worldwide. As far as the Commission is concerned, we really want WIPO to deliver against that objective. And of course, we hope for the initiatives that you already mentioned, the Design Law Treaty, to happen. In conclusion, bear with me, it's about growth and jobs as far as the EU is concerned. Intellectual property stimulate companies into investing in research and development, but also making intangibles into tangibles, Minister, like you said, in the single market. The EU IP infrastructure must be a tool for creating jobs in Europe. Our work, together with you, is to maintain this infrastructure, make it deliver on innovation in the market, in Europe, and our companies through this reward incentive, and be a castle of light for all of Europe. Thank you.
Yes, I would like to thank Kirsten Journa for this very interesting insight in the European newest trends. And after we heard the trends from world and Europe, I would like to give the floor to Raimons Aleksejenko, who is the Deputy State Secretary of the Ministry of Economy, and he will address a matter of Latvian innovating policy. Please, Mr. Aleksejenko, the floor is yours.
Minister, distinguished guests, ladies and gentlemen, on behalf of the Ministry of Economics of Republic of Latvia, it's my great pleasure to welcome you in Riga. And it's a pleasure to welcome you in this international conference of international property rights issue. Dear guests, the Latvian EU presidency has 3 horizontal key priorities within its 6-month agenda in the EU Council. The first is to promote the competitiveness of entrepreneurial capacity. Second one is to seize the EU digital opportunities. Third one, to strengthen European global outreach. These priorities are tightly related. Moreover, I would argue that well-functioning IPR regime both at the EU and national level is one of the preconditions to achieve these objectives and to succeed in terms of increased competitiveness, digital transformation, and operating in honest competitive environment at the global scale. Further development of the economy of Latvia will be still closely related to the export possibilities. Latvia's competitive advantage today are and will be mainly based in future on technological factors, improvement of production efficiency and innovation, but less on cheap labor force and low price of resources. According to this scenario, Latvia may reach an increase of 4% annual growth rate in the medium-term period. Therefore, we, as Latvia, need to create a platform for our businesses and citizens to assimilate and apply new knowledges and to innovate in order to enter knowledge-based economy and society. Latvia continues to make every effort to shift to this kind of economy model and enabling companies, regions and countries to become competitive in the global market. Today we see that intellectual property potential developed by companies, especially SMEs, and universities mainly remain underutilized. Therefore, we need not only to support efforts of companies and research to protect this and use their IPR, but also to raise awareness of the importance of intellectual property and its protection. In addition, we should also encourage new attitude to innovation, creativity, and entrepreneurial spirit. Another issue that I would like to stress is that EU member states should make greater effort to fully and legally implement the unitary patent system, so-called unitary patent package. I am convinced that simplification of the existing patent system will bring particular benefit to companies, in particular to SMEs, research community and individual investors by cutting costs and reinforcing the international market. Ladies and gentlemen, I would like to conclude with the 3 reflections from my side in the form of questions. Whether we sufficiently utilize the intellectual property for innovation, increased competitiveness and economical growth, and do we benefit enough from the intellectual property right protection? What are remaining challenges, and how can we listen and learn more intensively from each other in terms of IPR protection and to get higher commercial benefits from IPR as from valuable assets? And whether existing intellectual property regime both at national and EU level are appropriate for the digital age, especially in relation to the data availability and protection. I am confident that this conference will bring valuable discussion and offer solutions for improved IPR protection. I hope all of you will be able to discuss many interesting themes, including rhetorical questions that I highlighted. Besides, I am absolutely convinced that exchange of best practices is the best way to address existing challenges. Therefore, I invite you to be active and to engage in open and rigorous discussion. I hope all you will enjoy stay in Riga. I am looking forward to hear recommendations from this conference. Thank you very much, and good stay in Riga.
Thank you, Mr. Alexeyenko, and that brings to end our morning panel. I would like to once more thank all the panelists, the Minister Melbārde, Dr. Francis Gurry, Kirsten, Journa, Mr. Alexeyenko, and now it's a well-deserved coffee break. But before that, some housekeeping matters. If there is on the left outside of this room, if you want address any quick working matters, you can find the computers, printers, all the machines which will help you to do that. And our coffee pause is situated outside this conference room on your right. So have a nice coffee pause and see you back at 11:10. Thank you.